A witness on the stand repeats what someone else said outside of court. That out-of-court statement, if offered in court to prove the truth of the matter asserted, is hearsay under Federal Rule of Evidence 801C. Federal Rule of Evidence 802 mandates that hearsay is inadmissible unless a specific exception or exemption applies. The core inquiry is always the purpose for which the proponent offers the statement. A statement includes a person's oral or written assertion. It also includes nonverbal conduct intended as an assertion, according to Federal Rule of Evidence 801A. The declarant is the person who originally made the statement, defined in Federal Rule of Evidence 801B. If the statement is offered for any purpose other than proving the truth of the matter asserted, it is not hearsay. Non-hearsay statements are admissible, provided they meet the standard rules of relevance. The rule against hearsay prevents the jury from relying on unreliable evidence not subject to cross-examination. Statements offered for purposes other than proving the truth of the matter asserted are admissible non-hearsay. Common non-hearsay uses include proving the effect on the listener. For example, a statement offered to show notice, warning, or motive is admissible because the listener's reaction is relevant, not the truth of the statement itself. Statements offered to show the declarant's state of mind are non-hearsay if that state of mind is a relevant issue in the case. This includes showing the declarant's knowledge, belief, or sanity. Legally operative facts, also known as verbal acts, are non-hearsay because the words themselves create legal rights or obligations. Examples of verbal acts include words of contract formation, defamation, or making a gift. These statements are relevant simply because they were spoken. Impeachment of a witness using a prior inconsistent statement is also a non-hearsay use, as it attacks the witness's credibility rather than proving the truth of the prior assertion. Federal Rule of Evidence 801D1 defines certain prior statements by a declarant witness as non-hearsay exemptions. These exemptions apply only if the declarant testifies at the current trial or hearing and is subject to cross-examination concerning the prior statement. A prior inconsistent statement is exempted only if it was made under penalty of perjury at a trial, hearing, or deposition. If not made under oath, the prior inconsistent statement is admissible only for impeachment, not for the truth of the matter asserted. A prior consistent statement is exempted if offered to rehabilitate the witness's credibility after an attack of recent fabrication or improper influence or motive. The statement must have been made before the alleged improper influence or motive arose. A prior statement of identification of a person made after perceiving the person is also exempted from the definition of hearsay. Federal Rule of Evidence 801D2 exempts statements made by an opposing party from the definition of hearsay. This exemption applies regardless of whether the statement was against the party's interest when it was made. The exemption includes the party's own statement, whether made in an individual or representative capacity. Adoptive admissions occur when a party manifests belief in the truth of another's statement. This often happens by silence in circumstances where a reasonable person would have denied the assertion. Authorized statements are those made by a person whom the party authorized to speak on the subject. Statements by an agent or employee are exempted if they concern a matter within the scope of employment and were made during the existence of the employment relationship. Co-conspirator statements are exempted if they were made during and in furtherance of the conspiracy. The existence of the conspiracy and the party's participation must be established by a preponderance of the evidence, considering the statement itself, but requiring additional evidence. Federal Rule of Evidence 803 lists exceptions where hearsay is admissible regardless of whether the declarant is available to testify. A present-sense impression describes or explains an event or condition and must be made while or immediately after the declarant perceived it. An excited utterance relates to a startling event or condition made while the declarant was under the stress of excitement that the event caused. Statements of mental, emotional, or physical condition are admissible to prove the declarant's current condition or future intent. However, statements of memory or belief offered to prove the fact remembered or believed are generally excluded. Statements made for medical diagnosis or treatment are admissible if they are pertinent to diagnosis or treatment. This includes statements of past or present symptoms, medical history, and the cause of the condition. Recorded recollection is admissible if the witness once knew the facts but now cannot recall them fully enough to testify accurately. The record must accurately reflect that knowledge and may only be read into evidence, not received as an exhibit unless offered by an opposing party. Federal Rule of Evidence 804 exceptions require the declarant to be unavailable to testify. Unavailability includes claiming a privilege, refusing to testify despite a court order, demonstrating a lack of memory, or being deceased or suffering from a severe illness. Unavailability also applies if the declarant is absent and the proponent cannot procure their attendance by reasonable means. Former testimony is admissible if given under oath at a prior proceeding and the party against whom it is offered had an opportunity and similar motive to develop the testimony through direct, cross, or redirect examination. Statements against interest must be contrary to the declarant's property interest, pecuniary, or penal interest when made. If offered in a criminal case to exculpate the defendant, corroborating circumstances must clearly indicate the statement's trustworthiness. Dying declarations are admissible in homicide prosecutions or any civil case if the statement concerns the cause or circumstances of what the declarant believed to be impending death. Statements of personal or family history are also exceptions under Federal Rule of Evidence 804. The Sixth Amendment Confrontation Clause applies exclusively in criminal cases and acts as a constitutional overlay to the hearsay rules. It bars the admission of testimonial hearsay against a criminal defendant unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine the declarant. Testimonial statements are those made primarily to establish or prove past events potentially relevant to later criminal prosecution. Examples include affidavits or statements made during police interrogations when the immediate emergency has ended. Statements made primarily to enable police to meet an ongoing emergency are considered non-testimonial. Business records and statements made casually to friends or family are generally considered non-testimonial and do not trigger the Confrontation Clause analysis. Even if a statement falls under a Federal Rule of Evidence hearsay exception, it must still satisfy the Confrontation Clause if it is testimonial.